Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Jurisprudence Part 2 or Class 2. In this video, we are going to discuss the definitions of law. Don't be under the wrong impression that I am going to tell you the definitions of jurisprudence. Jurisprudence is the Latin word which is derived from jurisprudentia. That's all. Now we are going to discuss the different definitions given by the famous jurisprudence on law, only law. Actually, I told in the class only 3 important definitions given by very famous person, Salmond. Second is John Austin. Third is a philosopher, Plato. So definitions are too lengthy, a bit complicated. That's why I have made it simple. In simple terms, I am telling you the definitions. Salmond's definition. This is more important. Salmond says it's called, I will tell you. Law is the command of the sovereign. Law is the body of principles or aggregate of principles. Law is the total body of principles or the aggregate. That means some of the principles which are recognized or applied by the state. Why? In the administration of justice. This is Salmond's definition. So first of all, you have to understand it is an aggregate or it is a body of the principles of law. Principles, maybe governing principles. So who made the principles? The principles are made by the state. And who will apply them? The state. So the principles made and applied by the state. What for? The administration of justice. That's why please remember, administration of justice is a difficult task. Justice, you know, it's a, what type of word it is? Justice, it is a elusive word, E-L-U-S-A-V-E. That means, suppose A files a case against B and B is successful. B will openly say in the court that, yeah, justice is done to me. A will say, justice is not done to me. Then you tell me what is just. So that's why I told you, justice, fairness, equity and good conscience, they should be the credentials of the judge while preparing the judgment. So justice is an elusive aspect, but please remember, administration of justice. That's why sometimes the court may acquit the case. Sometimes the court may dismiss the case. The court may convict the accused. These are all the parts of the administration of justice. That's why I will told you that while defining a court, please remember, court is a place where justice is administered, not justice is delivered. Of course, we are digressing to some extent. So, definition of Salmond is that law is the body of principles applied by the state for the administration of justice. There is so much of meaning in it. Then second definition we are going to discuss is Austin's definition. John Austin. He is the propounder of the so-called analytical school. We will come to that separately. So John Austin, so his theory, his definition actually leads to just positivism, positive theory. What is this theory? Law is the command of the sovereign. Who is sovereign? Above whom nobody will be there. So law is the command by the sovereign, and it is the just like aggregate of rules, set of rules set by the politically superior people. Who are they? Like MLAs and MPs. Set by the politically superior people on the politically inferior or politically inferior means subordinates or people. Politically inferior people to regulate the conduct. So law is the command of the sovereign. The sovereign makes the law. So under the guidance of the sovereign, the so-called politically superior people, like the legislators in our present days, they make the law. On whom it will be applied? It will be applied on the politically inferior people or the public at large. And please remember, to regulate the conduct of the people. Of course, here you have to know the purpose of law. What for the law is there? Law is there to maintain law and order. Law is there. The purpose of law is to preserve peace. The purpose of law is to prevent crimes. Right? So in this connection, the regulation of the conduct will be there. The regulation of conduct. What is conduct and character? Character is inherent. Conduct is the way you have to behave in the society. Is it not? You have to conduct yourself in a proper way at the time of attending the seminar. That's all. But you should not look to your side. You should not peep into, or you should not raise your voice during the seminar. That is the conduct. So if you don't follow the rules, if you don't conduct yourself properly, what happens? Then sanction will be there. Punishment will be there. So here this is called actually this Austin's definition says that the law is framed by the superior people to control the inferior people, and if they don't follow, definitely sanctions will be there. And now we are going to the third definition, that is Plato, very famous philosopher. So Plato defined as actually a sarcastic way, mankind should either give themselves a law, what for? To regulate their life. So mankind should frame the law to regulate themselves. If not, either they have to make the law, otherwise they have to live like live no better than the wildest of the wild beasts. So just like you live like a beast, of course, like animal, does it follow law? They don't have any law. So mankind must prepare or must have the law, what for? To regulate themselves, to conduct themselves in a proper way. So this is the definition given by Plato. Of course, there are so many others. Immanuel Kant. So he said, his definition is also important. Immanuel Kant says, law is the sum of the total conditions under which the personal wishes of one man can be combined with the personal wishes of another man in accordance with the general law of freedom. So yes, you can acquire the property, you can comment on the other person, but there are reasonable restrictions. So Immanuel Kant says definitely law should be there, but it should be acceptable or have some so-called reasonable restrictions. And Roscoe Pound is also another very great definition. Law is the body of principles, just like our Salmond, recognized or enforced by the public and regulate the tribunals in the administration of justice. Of course, since he is a foreign man, he uses the word tribunal. Tribunal means court. So it is the aggregate of principles set by the people themselves. That this is what is called sociological theory, set by the people, and it will be regulated by the tribunals. That means the courts. And different definitions also there. According to Hans Kelsen, law is pure. Of course, while discussing the normative theory or pure theory of law, we'll discuss what Hans Kelsen said. He's not an ordinary man. He has written the constitution of the so-called Austria. He was a professor, then he migrated to America. His policies were not accepted because he said law should be pure, no interference, even by the legal, even by the political, or so many things we will discuss at that particular time. And Jeremy Bentham, yes, his definition is also good, but we'll discuss his definition in the theory, because pleasure and playing theory, greatest happiness to the major people and some sorrow to the minor people. Likewise, different definitions are there. If you know one or two definitions, it will be sufficient. And Eyring, this also just 1 minute time is there. Eyring definition is, law is the form of the guarantee of the conditions of life. It is the form of guarantee of the conditions of life, like society, and assured by the state's power of constraint. Definitely you will be given the liberty, but it will be constrained to some extent. So this is the link between liberty and constraint. So that is what we call as reasonable restrictions in our constitution. So these are the important definitions. Of course, if you are thorough with the definition given by Salmond and Austin as well as Plato, I think it will be sufficient. With this, I am closing the session. Thank you very much.